Hi, good afternoon, everybody. My name is Alexander Rufus Isaacs, and I am the moderator of this afternoon's program about Section 230 of the Communications Decency Act. Before we begin, I have a couple of housekeeping announcements. You should have already received your materials in an email this morning. If you didn't, please let BHBA know. And you'll also receive your MCLE certificate shortly after the program. Please also take a minute to complete the survey that's included with the certificate. It's very helpful. This program is sponsored by Net Reputation. Net Reputation offers a wide range of proven, industry-leading online management solutions you won't find anywhere else, from personalized individual reputation management, removal and online privacy services, to combating negative online publications. Net Reputation can clean and build a positive online reputation for your clients. Now, onto the program. In 1990, a company called Cubby was the subject of an unfavorable article in a newsletter that was distributed online by CompuServe. Cubby later filed the first lawsuit that sought to impose liability on an internet service for third-party content. Other cases followed, which added to the uncertainty as to how, if at all, an online distributor of such content should be treated differently than, say, a bricks and mortar bookstore. In 1996, a bill to address the problems came before Congress. There appears to have been a limited understanding of the ramifications of this bill, but it passed into law and became Section 230. Let's take a quick look at the statute. So here's the bill here. It's 47 USCA Section 230. Congress starts off by making certain findings about the developing nature of the internet and all of the benefits that it came with it. It goes on to announce certain policies to promote the continued development of the internet. I think interestingly, it says to preserve the vibrant and competitive free market that presently exists for the internet, encouraging various technologies, blocking, filtering. And here in subsection C1 are the key words. No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. That's what all the fuss is about, ladies and gentlemen. The the act also has some other carve-outs, for example, for criminal law, for IP, for sex trafficking, and it has a number of definitions later on in the section, over which there's been a considerable amount of litigation. But in any event, the effect of the 26 words has been essentially to immunize tech companies from liability for content created by others, whether or not they decide to moderate that content. And so this allows social networks, review websites, and the like to host content provided by millions of users without having to go to court every time they leave up a post that someone considers objectionable, or to take one down that is not. Last year, the Trump administration sought to strip social media platforms of Section 230 protections because of their alleged bias against conservatives. At the other end of the spectrum, there is a concern that platforms are not doing enough to police themselves by combating disinformation, and that victims of cyber harassment have no redress because the harassers cannot be identified or found, and the victims cannot sue platforms which distribute the content because of their Section 230 immunity. This is a 1-hour program. Frankly, I wish we had more time. Our aim is to provide you with some background about Section 230, and we're going to follow that with a discussion of the problems that it's created and whether it's possible to solve them. If you have any questions, please use the chat function, and if we have time, I will put them to the panel. Given the time constraints, I'm going to introduce our panelists now briefly, but their full bios are in the materials. I'm going to start with Kathy Gellis. Kathy began her career as an internet professional and webmaster in Silicon Valley in France. She later became a lawyer based in the Bay Area who specializes in the convergence of technology and civil liberties. Her practice includes advocacy and counsel relating to free speech, privacy, and other innovative policy matters affecting technology use and development, with particular focus on how these issues interact with media, with internet platforms, and how the law affecting platforms also affects the public. Douglas Morrell is a partner at Greenberg Glusker, Fields Claman and Mactinger LLP. He practices general corporate business litigation and has spoken and written widely on the subject of reforming Section 230 and authored an amicus brief to the California Supreme Court in Hassel versus Byrd, which we'll be discussing later. Doug also litigates constitutional law questions which help protect immigrant rights, prevent the electoral disenfranchisement of minority communities, and enforce freedom of information, public records, and other government access statutes. Carrie Goldberg is founder of victim rights law firm C.A. Goldberg, PLLC. The Brooklyn firm does groundbreaking work nationally fighting for targets of sexual violence online and off. Landmark cases include Herrick versus Grindr, which introduced the novel legal approach of applying product liability law to dangerous tech products, and KM versus City of New York, which is the highest known recovery in a Title IX case in New York City. Carrie has been central in national and local legislative reform for revenge porn, sextortion, and civil statute of limitations for sex offenses. The firm has removed hundreds of abuse media accounts and over 30,000 naked images off the internet published without her client's consent, has sent 24 stalkers, abusers, and rapists to jail, and has opened 7 Title IX federal investigations. Jeff Kosseff is an assistant professor of cybersecurity law at the United States Naval Academy. Before becoming a lawyer, he was a technology and political journalist for the Oregonian and was a finalist for the Pulitzer Prize for National Reporting and recipient of the George Polk Award for National Reporting. Jeff then clerked for Judge Milan D. Smith Jr. of the Ninth Circuit and others, and later practiced cybersecurity, privacy, and First Amendment law at Covington and Burling. His 2019 book, 26 Words That Created the Internet, is a history of Section 230. He's also the author of Cybersecurity Law, a textbook and treatise, and his articles have appeared in numerous law reviews and technology law journals. So I'm going to hand over now to Jeff, who'll kick us off with a brief history of Section 230, which starts fittingly for this program with a case involving a bookstore on what is now Skid Row in downtown LA.
Thank you so much for having me. I have to give a disclaimer before I start talking that everything I say is only on my behalf, not on behalf of the Naval Academy, the Department of Navy, the Department of Defense, the federal government, just me. And yeah, so it's exciting to be here. And you're exactly right. When you look at why we have Section 230, you have to think back to something that happened in Los Angeles at 5th and Main. And I'm sorry, I don't know exactly. When I clerked, my judge's chambers were in El Segundo, so I lived in Hermosa Beach, and I largely avoided Los Angeles altogether, and that was great. But I know it's right now locked right now. But it was a bookstore that was run by Eliezer Smith, who was a 72-year-old immigrant from Poland. And there was an LAPD vice officer who went into the store, and he saw a book and a really bad erotic novel called Sweeter Than Life that the LAPD officer determined was criminally obscene. So Mr. Smith is prosecuted under a Los Angeles ordinance that says it's illegal for any store to even just possess for sale any obscene material. So he's convicted in LA Municipal Court and sentenced to 30 days in jail. Fortunately for Mr. Smith, his case catches the attention of a civil rights attorney who appeals the case all the way up to the Supreme Court. And what the Supreme Court says is that even though obscene speech is not protected by the First Amendment, it's the LA ordinance was unconstitutional because it applied regardless of whether Mr. Smith knew or had reason to know or had any scienter of the actual contents. And Mr. Smith, he was able to read, but he said, I could read maybe 3 books a year, and he sold thousands of books. So the Supreme Court said it would create really a chilling effect if you expected a bookseller to review every book, because what that would do is he not only sell fewer obscene books, but he just sell fewer books altogether. So that basically sets in motion it helps to shape the common law standards, not just for obscenity, but also for defamation. When it comes to what is the liability standard for a distributor of someone else's speech. And what the courts generally, and it varies a little bit, the Supreme Court gives a little more guidance, but it mainly develops out of the lower courts. Actually, also in a case in LA involving the actor Ken Osmond, who played Eddie Haskell on Leave It to Beaver, but that's a whole other story that I won't get into now. But basically what the courts say is that distributors are only liable for someone else's content if they know or have reason to know of the defamatory or illegal content. And that works pretty well. There's some cases, not a ton, throughout the 60s, 70s, and 80s, usually involving bookstores. But then we get to the case that was just discussed, the CompuServe case. And so this is a case, the opinion comes out in 1991, where CompuServe is sued for an allegedly defamatory article in a newsletter that was posted on one of its forums. And CompuServe, they didn't have moderators. They did have decision-making authority, whether to have a forum or to have a newsletter, but they weren't really hands-on like you currently see with current social media. They took a relatively hands-off approach. And what the judge in that case said was that he dismissed the case on summary judgment. And he said, CompuServe is like a distributor because it doesn't exercise the requisite editorial control. And there was no, CompuServe didn't know, it had no reason to know that this article was allegedly defamatory, so I'm going to get rid of this. Okay, so far so good for platforms, but there is the big competitor to CompuServe, which is Prodigy. Now, as a side note, it is really hard to teach these cases to undergrads now because they have no idea what I'm talking about. But Prodigy was the other big national online service, even before AOL. And Prodigy wanted to have a different business model. So they wanted to be the service that families use. So if the kid wanted to research for a homework assignment, they'd go to an online encyclopedia on Prodigy, that sort of thing. So they had chat rooms, they had bulletin boards, but they were much more tightly moderated. There were a lot of contract moderators, a lot of user content policies. And okay, sorry, I'm apparently having some problems with my microphone. So hopefully you can hear me. So Prodigy gets sued to the tune of $200 million for comments in a financial bulletin board that are placed by an anonymous user about actually the person who was the basis for for Jonah Hill's character in Wolf of Wall Street, accusing him of fraudulent activities. So he sues, and Prodigy asks this New York State trial court to declare it to be a distributor, just like CompuServe was. And the trial judge issues an opinion in 1995 that says, no, you're not a distributor. You're more like a newspaper than a newsstand because you exercise editorial control. So you're a publisher, and a publisher is just as liable for the words that it publishes as the person who speaks it. So this got a lot of attention particularly for a single judge opinion from a state trial court judge, because when you combine it with the CompuServe case, it has the impact of saying, okay, if you're an online platform, you reduce your liability by not doing any moderation. And so this is 1995, and this is just as the internet is becoming more than just an academic and military technology, and it's something that's being increasingly placed not only in homes, but in libraries and schools. And there was a real panic over access to pornography, legal pornography, but children being able to go on the internet and access pornography. That was really the big focus. There were cover stories on Newsweek and Time about cyber pornography. And so at the time, the telecom laws for the federal government were being revamped for the first time in 60 years. So most of the focus was on things like local telephone rates and long distance phone competition and stuff that sounds pretty antiquated right now. But there in the Senate, in their version of the telecom bill, they created the Communications Decency Act, which imposed criminal penalties for the transmission of indecent content, not obscene, but just indecent content. And a lot of people, including House members, recognized that this had real constitutional problems. So that's where Section 230 came in. Chris Cox and Ron Wyden, who were both in the House at the time, they introduced what was originally the Internet Freedom and Family Empowerment Act, which basically it essentially says that if you're the platform, unless an exception for something like federal criminal law or intellectual property law applies, if you're a platform, you are not going to be held liable for the speech that someone else creates. So the idea is hold the speaker accountable, don't hold the platform accountable, and also that the platform will not be liable for making good faith efforts to remove objectionable content. So both the Senate and the House versions, in some sort of weird political compromise, get included in the final bill that's signed into law in February 1996, even though they kind of conflict with one another. But pretty soon, the day that it's signed into law, a bunch of civil liberties groups challenged the Senate's part, the Communications Decency Act. That goes to the Supreme Court and gets struck down as unconstitutional. So Section 230 never really was part of the Communications Decency Act. It's only called that because it's in the same title of the Telecom Act as the law that was struck down. So what we have is remaining of that title is Section 230. And we still barely got any media coverage. And it really did not get attention until a year later when the Fourth Circuit, and I'm running out of time, so I won't explain the case too much, but the Fourth Circuit interpreted Section 230 very broadly to say that it applies, it doesn't just apply, some people argued that what it could do is mean that all online services are distributors, meaning they become liable if they knew or had reason to know. That's what the plaintiff in that case argued. But the Fourth Circuit took AOL's much broader interpretation, saying that not treating an online service as a publisher means no liability at all for other people's content unless an exception applies. And that's basically been the broad interpretation that courts have taken for more than a quarter century now.
Jeff, thank you very much for the introduction. Carrie, I have a question for you. Can you tell us about the case you handled, Herrick versus Grindr, and what can be done to prevent that situation from happening again? And also, I'd like to ask you how significant you think the recent Lemmon versus Snap decision was in providing a basis to get around 230 by suing for a dangerous product.
Sure. I'm really happy to be here, by the way. So Jeff actually launches me into this really easily because the Fourth Circuit case, Zeron, is the bane of my existence. And it really messed me up when I was trying to get justice for my client, Matthew, against a local to you all California company, Grindr, based out of Venice at the time. So my client, Matthew, he lived in Manhattan. He was a waiter / model / reality star. And he just ended an abusive relationship. And his ex-boyfriend decided to get even with him by impersonating Matthew on the gay dating app Grindr. And using Grindr's patented geolocating technology, his ex started creating profiles with Matthew's picture and indicating that Matthew had rape fantasies. And then he would send people to Matthew's job and to his home, unwitting people, like thinking that Matthew wanted to have sex with them. And it happened over 1,200 times that these people came in person to Matthew's home. And he, Matthew did what anyone would do. He reported it to the police 10 times. He tried to get an order of protection and did get one against his ex, and then kept trying to get law enforcers to enforce it. And he kept reporting the impersonating profiles to Grindr, and they just ignored him. And when Matthew came to me, he was at his wit's end. He was very upset and depressed and endangered. And I thought we would be able to easily just get Grindr to ban this user, and then they blew me off as well. And so I went to court to get a restraining order that required Grindr to ban this man, and they ignored that. And finally, when the lawyer showed up to court, they said that they didn't have the technology to ban a user, which to us was just absurd. They have one of the most successful dating apps in the history of the universe, and it's just so foreseeable that sometimes a hookup app would be used by abusers and rapists and predators. We see it at my firm all the time. And to not build into the product design a method to both respond to victims and to exclude abusive users was just really negligent. And I was very familiar with Section 230 at the time that I brought the case. And so I was, very deliberate in not suing Grindr for any content that was on the profiles or anything that the ex-boyfriend said or on, in the direct messages. We didn't even have that information. Instead, we decided to sue them for releasing a defectively designed and manufactured product into the marketplace. And our judge in SDNY thought we were totally stupid. She dismissed it under Section 230. Second Circuit affirmed that. We got tons of criticism all over the country from people who thought it was just the stupidest legal theory. And then 3 weeks ago, the Ninth Circuit upheld the decision in a different case, but it's the exact same theory in a case against Snapchat, where some parents sued Snapchat after their sons used a speed filter that was on Snapchat and then got into a horrible accident and died. The Ninth Circuit said that yes, actually, you can hold tech companies liable for product defects. And so there's question right now about whether or not that'll create a circuit split with the Second Circuit. I'm personally really delighted and vindicated that finally we're getting out of this Zarin trap, and that we can actually be sensibly suing tech companies for really extreme dangers that happen to people. These are not cases that are about defamation or calling somebody a bitch on Twitter. They're about really, really serious harms. And that's my time, more or less.
Carrie, thank you. Does any other members of the panel have any thoughts on Lemmon and Grindr?
I do. I don't share Carrie's enthusiasm for the outcome of Lemmon v. Snap. I mean, I can see from her perspective, it did seem to endorse the theory that she's working with. I'm just deeply concerned about the upshot of where that goes, because it seems like it eats the whole. I think one thing that we need to kind of stay focused on, and going back to Jeff's stories about the history of where this law came from, is that this is about speech. This is about making sure that the right of free expression can exist in a meaningful way, including online, and that we don't accidentally obliviate all this expression, including beneficial, legal, necessary expression, in the process of trying to carefully control all the expression, including the fact that some of it is bad, terrible, even to the point of being illegal. In order to do that, it means we have to have some practical realities and give platforms, in terms of putting that online, we have to have a durable, robust, widespread, broad system of protection, because if we don't, The consequences are maybe you'll get rid of the bad stuff, although I think that becomes a little iffy, but it will eat the whole and make it impossible to get the good stuff. And if we take it in terms of products liability itself, about, well, you designed a product that people could use to speak harmfully, I think that applies to absolutely every single internet service that we have. There's sort of this tendency to look at it that Snap was something different, Grindr something different, that there's something about the very specialized services or the specialized apps that are different from some of the general purpose, like a Twitter or a Facebook. But I think it's a difference without distinction. People can go to Twitter and post death threats. So by the same theory that would say that any of these other services, because their products could be used for ill, need to be liable under negligent design theory, I think that kicks out every single service that in any way facilitates any sort of expression at all, because expression can be used for ill. So much to get to and so many ideas, and I'm sure we don't agree and stuff, and there's more to cover, but I want to throw that out there. The eye on the ball is what happens to online speech. And if you start to clamp down on some of these protections, are we impinging on something that we really do need to protect much better than we might be?
So if I could just, as the one person I think on the panel who's unfortunately inside the Beltway, physically at least, and I meet with staffers and members of Congress all the time, my optimism about Section 230's continued survival goes down every week, the more and more meetings that I'm having about it. And I think for the Lemmon v. Snap case, I have questions about the merits of the case and things like proximate cause and whether that will succeed. And that's really not my expertise. What I will say is that had the Ninth Circuit opinion been different, I think that Section 230, my optimism for Section 230 continuing to survive would be even less than it is now. We saw it in Backpage, where Section 230 is not written in stone. And when we saw what happened with Backpage and Congress passing a law, the Snapchat case is horrific facts. And these are all, what's alleged is that there have been accidents and that this is a known threat that was happening. And I think that, yes, you can argue about whether the Section 230 outcome was correct based on precedent. But what I'm saying is, from a practical perspective, you have 535 people who control the fate of Section 230. And if they see the headline saying, this is what Section 230 protects, I think Section 230 survival is even less likely. So I think that's just sort of part of the political aspect of this.
Could one of you answer the following question, which is that, as I understand the issue in Lemmon, Snapchat had this feature that if the user was traveling at a certain speed, that speed would be recorded on their app, and their friends can see they're driving at 30 miles an hour or 130 miles an hour. And the court considered that dangerous because it understood that Snapchat was essentially encouraging users to drive too fast. Where is the speech in that element? And, that 230 should have addressed.
One concern I have about the decision is I think its analysis was a little facile. I think there were assumptions and rumors that it presumed as facts in the record upon which it predicated the decision, and that seems a little bit sloppy. But one of the things is that they actually noticed themselves there was a speech issue, because they used the word document in the decision, where these kids were documenting how fast they went. So documentation is an expressive activity that the app was facilitating. Now, then it also makes some presumptions about, well, of course, that was inherently dangerous. But that doesn't even necessarily follow either, because what if you were in a plane and you're moving fast and your GPS is going to register you as moving fast? That's going to get documented, but it doesn't follow that there's inherently a danger with that. You could be on a bike documenting your speed at 20 miles an hour, and it would be plenty dangerous for you to be doing that. And they actually had, as part of the decision, the screenshot, which the screenshot had a warning on it that says, don't snap and drive. So the problem with these cases is, the facts are terrible. Like, this is a bad thing that happened, and we want to remediate a bad thing that happened. And there's a tremendous temptation for the sympathies of the courts to lean that way. And that's not a terrible thing, but the upshot is there's a bigger question at stake about what is the rule that's going to allow us to fix this one situation that won't create further problems, especially for free expression at large, with whatever we concoct to make a remedy here. And that's the bit that's very problematic about the speech. It does not scale successfully, reliably, safely to other forms of online speech.
There's a question from the audience for you, Kathy, from Marla Levine, saying if Carrie's client, Matthew Herrick, had come to you for representation instead of Carrie, what would you have advised him?
Well, first, I would have actually probably sent him to Carrie, because Carrie is a plaintiff's lawyer and she's dedicated to making sure that when people are hurt, she can try to undo that. And in many ways, I absolutely want to support that. Like the fact that he couldn't get the restraining order, he couldn't get the cops to come. I want to put Carrie on that job to go fix that, because that was absolutely the remedy he needed. He needed to hold that schmuck responsible. And her dogged determination is exactly the sort of counsel that she needs. The kind of lawyer I am, though, is I'm a systemic lawyer. I'm trying to look at the whole picture of, I call it fix it for everyone advocacy, where I tend to have less direct representation, but more I want to figure out what is going to scale and what is going to work for the most people in the most situations. So I would not be the right lawyer for her client because he needed a fix that I don't deliver. But what I do try to deliver is an ecosystem where people who do get hurt are always able to speak out against what is hurting them. And the reason I push back on some of these pushes to reduce 230, et cetera, is because I think the upshot of that reduction in platform protection is going to turn into a loss of expressive freedom on a practical level. And that's a thing I want to avoid.
Kathy, thank you very much. We're now going to switch the focus to another case in which Doug played a role. Doug, question for you. Tell us about Hassel and Bird and what can be done to prevent that situation from happening again.
Great. Thanks, Ann, for inviting me to join this august panel. I feel humbled by the company I am keeping here. Let me begin, though, by first joining Jeff in a disclaimer. I'm speaking for myself, not on behalf of my firm, any of its partners, or any of its clients. The case that I was involved in, not as counsel, but as simply author of an amicus brief that was prepared on behalf of Berkeley Law Dean Erwin Chemerinsky, who is a prominent First Amendment advocate in this country, along with a number of others. We did an amicus brief on the losing side of a case that was decided by the California Supreme Court in July of 2018. And that case involved the following scenario. But if I were to sum up the case in 3 words, it would be that defamation lives forever. So here's what occurred. Ava Bird sought to engage the services of personal injury attorney Dawn Hassel. And due to Hassel's disagreement with how Bird wanted her case handled, Hassel withdrew from the representation within weeks of their initial consultation. But several months later, a series of false, pseudonymous, 1-star reviews of Hassel and her firm began appearing on Yelp. Those 1-star reviews were accompanied by commentary that, gee, I wish I could give her a 0-star review, but Yelp does not permit that. In any event, Hassel recognized the author as her putative client, Bird, and emailed her in an attempt to resolve the matter. Bird responded, but refused to take down or modify any of her false and highly negative reviews. Hassel then sued for defamation, false light invasion of privacy, and intentional infliction of emotional distress. She sought both monetary damages as well as a prohibitory injunction for allowing the defamatory reviews to remain on Yelp. Hassel, though, and this is important, Hassel did not name Yelp as a co-defendant and didn't do so for at least 2 rather understandable reasons. The first is Section 230, what we were talking about today. The second is the concern that if she had, she would have been subjected to a motion under California's anti-SLAPP statute, CCP 425-16, which requires that if you fail to prevail, automatically in the case of a defendant, fee shifting takes place and you will be responsible for paying the other side's fees. In any event, the case proceeds. Hassel ultimately obtains a default judgment for defamation, obtains significant monetary damages, and an injunction that each and every defamatory review published or caused to be published by her be removed from Yelp. And as is usual in injunction actions, those provisions apply to Bird and her agents, officers, employees, or representatives, or anyone acting on her behalf. But after Yelp was served with a copy of that default judgment, it refused to remove any of the adjudicated defamatory reviews. And the following month, Yelp filed a motion to set aside and vacate the judgment on the grounds that it was indeed barred by Section 230. Importantly, though, I think Yelp didn't challenge the trial court's substantive ruling that all of Bird's postings were indeed defamatory. Yelp's motion was denied, and Yelp appealed. They lost before the first DCA, but they prevailed in the California Supreme Court in a rather controversial 4-3 decision. The plurality opinion there by Chief Justice Tani Cantillo-Sacouye said, defined liability very narrowly, and said, by contrast, the dissenters said that the claim ought to be determined in favor of Hassel, and that the liability provision should be read broadly. US Supreme Court denied cert, and the upshot, I think, is a couple of things. If this obstinate author of an adjudicated, if any obstinate author of an adjudicated defamatory posting can successfully mask his or her identity, or is judgment proof like Bird was, or resides outside the jurisdictional reach of the courts, a removal order addressed to that individual will have no impact whatsoever. And the only remedy currently available to victims of such conduct is to hope that platforms where such postings appear will voluntarily create and scrupulously enforce, I should say, robust terms of use that prohibit such conduct. But I don't, from my point of view, that is insufficient. And there are a number of potential remedies that I think could be employed, including trying to statutorily define what liability is, which is currently an undefined term in Section 230. But the other remedy that I would propose, and I'd love to hear others' thoughts about this, is to implement a DMCA type notice and takedown, or perhaps better yet, a modified notice and stay down provision that for defamatory conduct, such as exists already for copyright infringing or allegedly copyright infringing content. And so maybe I shall, since I see my time is out, I will stop there.
Thank you very much, Doug. Would other members of the panel like to chip in?
Sure, I'd love to. And I really appreciate Douglas's perspective on this, because as somebody that deals with a lot of revenge porn cases and people who have horrible content up, what was so hair-splitting about the Hassel decision is that, okay, how is a victim even supposed to not sue? What if their only objective is to just get that horrible content removed? They just want an injunction. That decision said they can't even do that. It said that, victims don't have, because of Section 230, you can't name the platform. But if you don't name the platform and you try to get an injunction, then you're violating the platform's due process. And so, we get a lot of people saying, oh, there's just going to be a race to the courts if we change Section 230, and all these plaintiff lawyers and victims are going to just attack and swarm because they want money. But sometimes they don't even want money. They just want that, the nude pictures off the internet, and we can't even get that. Zarin has been interpreted so extravagantly that it even applies to injunctive relief.
I'd like to pose this question to the panel. Is there a legislative fix here, an amendment providing essentially that 230 is no defense against a judgment requiring content to be removed? Is that feasible?
I think so. I testified, so I'm not in support of a DMCA. I think the DMCA, I see why we would do that. If you look at the DMCA, there's definitely been abuse of that system. But in terms of default judge or just have injunctive relief, I testified in the Senate last year in support. I don't think that the Hassel decision was correctly decided. I think that if material has been adjudicated to be defamatory, I don't think Section 230 does or should protect it. I understand concerns that people have about, possibly being able to forge court orders. If that's the case, that's a much bigger problem than Section 230. And also the concern about what level of scrutiny default judgments receive, and I understand that. But I think that I think there could be the PACT Act, actually, which Senators Thune and Schatz proposed, actually does contain a provision that addresses that.
Also, go ahead, Kathy.
Well, there's an assumption here that the speech was adjudicated, and that's an assumption that we can't predicate this argument on because it's not actually true. It was a default judgment, and there's an underlying concern that they actually didn't even name the correct defendant. And part of Yelp's hesitancy in removing it was they actually felt that it was protected speech and that there was actually nothing to vindicate it on to have it. We never adjudicated this, basically. And it puts us in the realm of what ends up being wrong with the DMCA, which is we keep running into a system of prior restraint where unadjudicated speech keeps getting disappeared, even though it may be perfectly lawful. And that's intolerable under the First Amendment and not something that we should want. The procedural difficulties in Hassel v. Byrd exemplify why people like me are pushing back on this all the time, because there's no way to be safe to make sure that we're not accidentally censoring somebody who has a right to speak and to be there. And in terms of something that Carrie said about, well, we can't get the injunction. The revenge porn is terrible, but sometimes what people do in fact want is not the damages, but the power to control what somebody else can say. And to unthrow myself under the bus, because I talked about I'm not the direct helper lawyer, that's actually not true. One of the types of advocacy I do directly for clients is defend them when somebody's trying to unmask their anonymous criticism. And I've done that in cases where anonymous bloggers have criticized powerful people, and the powerful people tried to unmask them, not because they wanted to extract money, but because they wanted the leverage to be able to ruin their lives. That's exactly what Carrie's trying to fight, from people with power from ruining other people's lives. And sometimes you need to stand up and fortify the First Amendment to make sure that the powerful can't abuse people like that.
If I can just comment on a couple things. First, with respect to the Hassel case itself, in California, at least, you can't get a default judgment without proving up your case. Now, it may well be that there wasn't an adversary on the other side to argue, but nevertheless, the court, required that there be proof that the material was indeed false and defamatory. So I think that that's a sort of a false argument. But the other point is, as I mentioned, that in their motion to vacate, Yelp didn't argue that these were not defamatory. They didn't make that claim, and they could have, or they could have sought to undertake other proceedings in order to give them the opportunity to demonstrate that that was the case. But one thing I did want to mention is that there's another bill in Congress in the hopper as of February of this year called the Safe Tech Act that was introduced by Senator Warner. And it has a provision in it that excludes injunctive relief from the Good Samaritan immunity. And it particularly says that the Section 230 provision that we're talking about doesn't apply to any request for injunctive relief from the failure of an interactive computer service to remove, restrict access to, or availability of, or prevent dissemination of material that is likely to cause irreparable harm. Now, you obviously need to demonstrate irreparable harm, but in the ordinary injunctive situation, that's an element. So that is a potential, I think, legislative fix to this problem.
I think if I'm going to jump in here, we could spend a lot more time talking about Hassel and Bird, but I think it's time now to move to a question I have for Kathy, which follows on from what Doug was just talking about. Kathy, what are some of the things that people are currently proposing legislatively to fix Section 230, and will they?
So I put the fix in. I don't believe, okay, there's three things I think you could fix with Section 230. One, there's a typo in it. You could get rid of the typo. Two, you could undo FOSTA, which is a recent amendment that's got a body count attached to it, and I'm not exaggerating. And three, you could close the IP exemption as well, because that weakens the protection available for platforms, puts them in the realm of the more conditional and weaker DMCA, and we see all sorts of prior restraint-driven censorship. I think it's not a good thing. We should not be tolerating a regulatory system that causes speech to be censored. I think it offends the First Amendment, and therefore it should offend our democratic instincts, because that's not a good thing. But nonetheless, people are trying to do different things, and they kind of boil down into a couple of categories. Now, a big reason why I think none of them are good is because of the basic effect of the benefit of Section 230 is that, as Jeff talked about in the history, there were things that the platforms were inclined to do that we wanted them to do: make good speech available and eliminate the detrimental speech. And we wanted them to do that, and they had their own First Amendment rights to do the best they could to do that. The problem is, it's great if you have the legal right to do it, but if you're going to get depleted by all sorts of litigation challenging your ability to exercise that right, what's the point of having the right? You're just going to get depleted and disappear, and really not be able to stay in the business of offering a service that's going to facilitate others' expression. So if we wanted to have an internet that could have a wide variety of services to facilitate other people's expression, we needed to make something that was durable to protect them, to make it safe to do so. And Section 230 works because it's fairly clear. It's the 26 words. It's very clear, fairly straightforward, very few exceptions and holes. But we do see that terrible things can happen to speech where it disappears when all of a sudden we get in the neighborhood of finding those holes. So I'm not a fan of any particular remedy that is going to essentially create a litigation battlefield, where if you have to litigate about whether 230 applies to you or not, what's the point of having it apply to you at all? At that point, you might as well just litigate on the straight merits, assuming you can afford to litigate at all. And when we think about the scale of, even the big platforms with lots of money are also handling a gazillion bits of information. If all of those tweets turned into lawsuits, we would not have a Twitter very quickly. So you need something that's broad, predictable, robust enough to actually do the job that it's doing. But things that people are trying to do are add more carve-outs, for instance. These vary in what they're proposed. One thing that comes up a lot is a carve-out to say, if the thing wrong with the content, like right now we have a few carve-outs. If the thing wrong with the content is that it violates federal criminal law, Section 230 doesn't apply, and that's been there from the beginning. If the thing that is wrong with the content is that it violates an intellectual property right, Section 230 doesn't apply. That's been there from the beginning. Now we have FOSTA, that amendment I said had a body count. It's a very unclear thing that seems to say if the thing wrong with the content is it facilitated sex trafficking, Section 230 doesn't apply, which kind of makes sense, but in some degree was unnecessary because you already had the federal criminal law exemption, and it's so poorly written that the upshot of it is that basically an awful lot of lawful but adult content is no longer facilitated online because the platforms are like, this is not durable, we're going to have to litigate it, we might end up in criminal trouble, we just can't touch the stuff. And so we lost an avenue for speech that might be lawful or speech that might be necessary, like sex workers, where even if it's not lawful, being on platforms to facilitate sex work made sure that they could screen people and be safer. And when they got kicked off the platforms or the platforms closed down, they ended up in the streets, and they're a lot more physically vulnerable if they're in the streets. So taking away their platform, not very effective for actually looking out for their interests. So carve-outs are a little bit questionable because that becomes one of the terrains that we're going to look at. But one of them is anti-discrimination law, political ads comes up, and you understand what's the policy drivers, where misinformation and this and the other thing, and we don't want discrimination, that's bad. But again, battlefields, litigation, loss of clarity, you're going to create pressure that's going to drive away legitimate speech. Mandatory transparency reports. I like transparency reports. I especially like them when they report what the pressures were that were driving platform decisions. And I think it's a good thing to want our platforms to be transparent about what is driving their decisions to leave up content, take down content, etc. But mandatory transparency reports, compelled speech, not cool with the First Amendment. And they do have the First Amendment right to be arbitrary, but if they have to report in how they were arbitrary, they don't get to be arbitrary. And we may not really like when they make their decisions arbitrarily, but they do have the right to do it. And we impinge on First Amendment rights at our peril, because if they're good for the people we hate, they're going to still work for us too when we think it's actually more important to deploy them. Big thing that came up with the Safe Tech Act, but that's not the only example. I'm seeing it in some legal decisions as well, but this idea that transactional speech is somehow not eligible to Section 230 or speech that's fully deserving of First Amendment protections. And the Safe Tech Act, and granted, this is mostly a drafting error, but I think this is the direction they want to go in, essentially kills the internet economy, because it basically says if you're making money off of the speech that you're facilitating, Section 230 doesn't apply. But everybody needs to make money in some form in order to keep their service going. So they seem to be wanting to target certain types of speech that maybe take a bit out of the transaction, as that's the model that funds them, but there's no principled reason to divide it that way. And quite frankly, the whole thing eats everything. If you make money, like the only internet could exist is an internet that had enough money, nonprofit from the outset, that they could fund themselves for like a gazillion years, and nothing exists that meets that description, including a lot of the nonprofits like Wikipedia and stuff like that. So not good, but in general, this idea that if you're facilitating transactional speech, like I have a home to rent, people are missing the fact that this is still speech. It's just very specialized speech. And people make money off of facilitating that specialized speech, but it is still speech. And that's getting missed by some of these things. Then a big one, and I saw that it came up in a question or the chat, is mandatory moderation. And none of this makes sense, because it's either thou shalt not take this stuff down, or thou shalt keep this stuff up, and there is no way you're going to be able to reconcile that. The platforms have their own First Amendment discretion for good reason, because we cannot have rules about what speech is good and what speech is bad. And we know we can't have rules because look at how people don't agree. And that gets into the last point that I just wanted to bring up, which is that it's messing with the preemption provision, that Congress recognizes an internet platform is inherently interstate. Everybody, if you let this be subject to states, localities, counties, towns, whatever, they're not going to agree. And how can a platform that's providing an internet service that shows up everywhere possibly comply with all sorts of things, including things that don't agree? So if we think about it, what are the red states pushing right now in terms of their moderation policies, and what are the blue states pushing for what are their moderation policies? And the fact that they are so polarized and don't agree, why would we tempt ourselves to have this mess? So none of these are a good idea.
Thank you, Kathy, very much. Would other members of the panel like to jump in? I think you've silenced them, Kathy.
I guess I'll plug what I have been testifying about and writing about, and no one really cares too much about it as usual, which is that I think Kathy's exactly right about I talk with any member of Congress or their staff, obviously, who want to talk with me. I talk with them, and it really is like hearing two completely different concerns about what platforms are and are not doing. And so I've been proposing for a few years now for Congress to do something radical, and that is gather more facts about how moderation works, what's possible, what's not just legally, but operationally, technically, and have that inform this debate, perhaps through a nonpartisan commission that isn't as headline worthy as let's propose a bill that says this or that. But I feel like that's really missing from this debate right now. And I don't see any, with all the talks I've been having, I don't see any single reform gathering sufficient momentum, because you do have these very polarized views of what the internet should be. And I don't see how you reconcile them.
Let me just briefly pick up on something Kathy said at the end in terms of commercialism. I was speaking to a reporter this morning about a case that's pending in the Third Circuit called HEP versus Facebook, in which the issue is whether or not state right of publicity statutes and state common law right of publicity is or ought to be treated as an intellectual property right that's exempt under the under Section 230. That decision has already been made in the negative, I guess, so that it doesn't fall within the exemption by the Ninth Circuit many years ago in a case involving Perfect 10. But, you know, if the Third Circuit goes another way, maybe we've got a circuit split, and maybe there's an opportunity for the Supreme Court to do something that it has not done in the entire history of Section 230, which is to take a case. So we'll see.
I have a question for the panel, which is as follows. If we want to, as a policy provision, want to insulate platforms from third-party liability, but at the same time, if we want the victims, the clients of Carrie's, victims of cyber harassment, to have some recourse, then their recourse is surely against the bad speakers, the perpetrators, the trolls, and all of those people. But surely part of the problem is that the victims often can't find them or locate them because of the problems with anonymous speech and the problems with enforcing subpoenas, so that you can actually find out who this person is who's saying all these vile things about me. Wouldn't one fix be to make it easier for victims to locate and to sue the bad speakers, and at the same time to eliminate any further liability from the platforms?
Well, so thank you for plugging my next book, which is about anonymous speech. And I mean, this is an area where, I mean, there are sometimes, I mean, there's certain technology like Tor that some people use, some don't. But in terms of sort of the protections for anonymous speech, the courts have developed a strong but very far from absolute protections for anonymous speech when people issue subpoenas, and I mean, this really arose in the late 90s when Yahoo Finance started to become really popular, and employees would go online and trash their employers, and CEOs were furious because they'd never faced this sort of public criticism from their employees, and they would sue their anonymous posters, issue a subpoena with no intention of actually collecting damages usually, but just to unmask them, fire them, humiliate them. And the courts have developed, it depends on which court you're in, they're balancing tests where they have, there was a case called Auto Admit from, I think it was 2008, where the court actually applying this test did allow the unmasking of a really horrific harasser. But so the courts have balanced this. There actually was a member of Congress, I forgot which one, recently tweeted out, why don't we just require some sort of real name registration for everyone? And I think that would have substantial First Amendment problems if there were a law requiring it. But we have a pretty significant body of case law that deals with protecting anonymity for those reasons.
Yeah, and I'll add that as a civil lawyer, I think a lot of people in the audience also are plaintiffs' lawyers. You know, it's just not going to solve. There are always going to be bad guys out there who are doing horrific things. I've taken an 11-year-old client of mine who was targeted on Instagram and then manipulated and coerced into creating nude photos and videos and masturbation videos for this anonymous guy. Now, why would my client doesn't have a penny to her name? I'm a 13-person law firm. It doesn't make sense for somebody in this situation to start a multi-jurisdictional case that's going to be hundreds of hours of time against a psychopath that is going to be judgment proof. You're stopping one person when that same cause of action could be used against a platform that could actually motivate them to change their policies and procedures and use their behavioral detecting analysis that they exploit all of us with to actually catch sex predators who are serial sex predators that are abusing their platforms. I mean, it's just, I have lots of clients that are being attacked by 1,000 people. Are they supposed to just sue 1,000 people? Those are the types of speech-based problems that there's not a good solution for.
If I don't want to cut you off, but I think, and I'm saying like in the chat, there's a whole bunch of, well, why not this? This seems easy. Here's a problem you've just described. Surely this would be a fix. And maybe if that's all the question was, that would be true. But this is a large ecosystem that is essentially accounting for the free speech expressive rights of everyone. And it works together with pieces. And it's very difficult to load up in our heads what gets implicated. If we push in a little place on the system, what's the consequence of that? Right now, we're not talking so much about, like, I brought up my one client that was an anonymous speaker who spoke out at a critic, and then the critic tried to unmask him to go after him. But that's not the only example. If we want free speech to be a meaningful right, and I'm not entirely sure that it's politically popular these days to say that free speech should be a meaningful right, we have to decide things in certain ways or else that right will go away. And the things that keep me up at night are the situations where there is no expressive freedom. What happens to people who live in jurisdictions where they don't have a First Amendment? What happens to people who live in jurisdictions where there's no platform protection? What the pressures are? The fact that Twitter just got raided by the Indian government that was unhappy that Twitter labeled something that was disinformation as disinformation. These are scary things. When we tip the balance of power between who gets to do what to whom and who gets to set the rules and who gets to decide what people can think and say, the consequences are terrible. And so if it seems like I'm pushing back at, that poor Carrie's clients don't get the remedies that they would really like to have to be whole, I'm not unmindful to that, but I'm really desperately afraid of what happens if we give them the remedies of what happens to everybody else, because it just seems to line us all up for an awful lot of trouble that will give an awful lot of really bad people a lot more power to be bad.
We have to wrap up. We have time for one more contribution. Okay, well, we've run over time as it is. I have to say that while the debate has been going on, I've been reading the chat and Q&A functions, and I'm just want to apologize to everybody who's raised some really excellent points that we couldn't get to everything and put your questions to the panel, but it appears that Carrie in particular has been pretty active in responding. So she's really multitasking here, and I want to thank the panel very much. Each of you have really made interesting and significant contributions to this debate. And I would like to encourage those listening who wish to delve further into the murky waters of Section 230. I'm going to give an unashamed plug for Jeff's book, The 26 Words That Created the Internet. Doug and I have both been reading it and both really enjoyed it. It's an excellent place to come to delve with some of the finer points. And I also like to give a plug for a series that I watched on YouTube, moderated by Kate Clonick, who's a professor at St. John's. It's a 5-part, 7.5-hour series about Section 230 that went out last summer, I think hosted by Yale. So if anybody's interested, I recommend them. And with that, I'm going to wrap everything up. I'm going to thank the panel again very much for your contributions. And I want to thank everybody for attending. And with that, I think we're done. So thank you very much indeed.
Thank you.
Thank you. This was so great. Great questions. Amazing audience there in Beverly Hills.